Good afternoon, everyone. Thank you for joining us today. We're going to be going over some H2A specific changes here with Shawn Packer, our legal partner, and he's going to be going through details on that. And we can follow up with additional information after he goes through the points that we're going to be discussing. He did mention we will have a little bit of time for Q&A at the end of his talking points. So if you have anything, please locate the Q&A box or the chat box. Jamie's online as well, and she can be monitoring those questions, and we'll take as many of those at the end as well. One thing before turning it over to Shawn and talk about the regulation changes here recently is that, we all know we're on day 16 of a governmental shutdown. What that means for us in regards to H2A is that we cannot currently file or even access the online system with the U.S. Department of Labor to file any applications. To kind of put that in a timeline perspective for you, if you have a January 1st start date for your H2A application, the earliest date we can submit those are Saturday, October 18th. So that kind of gives us a time frame of what we're looking at, as this shutdown prolongs and things get further backlogged at the Department of Labor. Will determine how we can continue filing, for your spring needs. So if this rolls into November, I think there's going to be more of an impact on many H2A applications as many more employers have start dates that begin in February and so forth. So we'll keep you updated on that, but I don't want to get bogged down on, shutdown issues. We will address that more, once we get closer to the end of the month, if it becomes if it's still an issue. But for now, I want to turn it over to Shawn to kind of go over the points of these most recent changes and how that impacts how we're preparing your application to be filed for the 2026 season. Thank you, Shawn.
Thanks, Arnulfo. As Arnulfo mentioned, we actually had some flurry of action as we were going into the shutdown. On October 2nd, there was two what's called interim final rules. And basically what those are the rule goes effective immediately upon publication, and then they take comment after that publication. Generally, the way that this typically works with rulemaking is you get what's called a notice of proposed rulemaking, or an NPRM, as we like to call it. That usually gives you 30 to 60 days to comment. The department then takes those comments based on what their proposed rule was, and they, either make edits, or they come back and they say, we're not going to make an edit on this space or that space or whatever, and then they come out with what's called a final rule, and then that usually goes effective, usually 30 days or so after that publication. That process generally takes almost a year for things to go into effect. And so what we ended up having here in this particular situation is kind of a confluence of different things that happened. So there's been a flurry of litigation around the 2023 adverse effect wage rate rule, which I think many of you probably are aware of, disaggregated wages, as we call it. So if you had certain duties like truck driving, fence erecting, construction work, those types of things, instead of you getting your normal adverse effect wage rate that was issued under the Farm Labor Survey, they would disaggregate that, and they would give you an Occupational Employment Wage Statistics Survey wage, which we call the OEWS wage, of a heavy tractor trailer driver, or construction work, or fence erector, or first line supervisor, or just dependent on what those duties are. And oftentimes that wage was vastly higher than what the adverse effect wage rate that was reported by the Farm Labor Survey out of USDA. And so we would have situations where somebody would get a heavy tractor trailer driving job that's a $28 an hour job. And so we would have to figure out how to kind of bifurcate our job duties. So, typically under the old system, we would do, you do field harvesting, hand harvesting, whatever it might be. But we would also have ancillary duties of truck driving or whatnot. And under the 2023 rule, the truck driving duties would pull that wage all the way up to that $28, $25 an hour wage for everybody under that job order. And so there was a lot of litigation around it, and a case out of Louisiana Tech Vermilion, which is a sugarcane harvester, they actually won and ended up settling with the department as to vacating that rule. So on August 22nd, that rule was vacated, which basically meant that we were going to go back to the traditional rule that we had in 2010 that we had lived under for many, many years, where we were only issued one wage. It was the Farm Labor Survey wage. That was it. That was the only thing that was issued. Instead of this bifurcated, disaggregated wage that was issued. Shortly thereafter, the U.S. Department of Agriculture ended up saying that they were going to discontinue the Farm Labor Survey. And I do apologize. My dogs are going to go nuts right now because somebody just knocked on my door. But we're going to continue through this. So hopefully everybody can hear. So anyway, so the U.S. Department of Agriculture decided that they were going to discontinue the Farm Labor Survey, which is the survey that we have traditionally used for setting the adverse effect wage rate. So on the 22nd, you ended up having the vacatur of the 2023 rule that did this disaggregation aspect. And then on shortly thereafter, you had USDA say they're going to discontinue the Farm Labor Survey. Well, when we went back to that 2010 rule, that 2010 rule used the Farm Labor Survey specifically, and that's what was defined as what was going to be set as the adverse effect wage rate. So after this happened, we kind of go into this space of, okay, what do we do now? Because there's no other option for setting that farm labor, or for that adverse effect wage rate, because the Farm Labor Survey is not going to be issued this year. So the Department of Labor issued what's called this interim final rule, which goes into effect immediately, that changes how the wage rate is going to be set. And we'll get into the different changes that were made there. But ultimately, there was just this kind of vacuum that required the Department of Labor to issue this emergency rule, basically. So the government shuts down at 11:59 on October 1st. On October 2nd, the department publishes this new rule. It goes into effect immediately. So what does that basically mean? So any job order that was filed prior to October 2nd, when this rule goes into effect, is going to be processed under the 2010 regulations. So the regulations that we used to deal with, where we get the Farm Labor Survey wage that is set by USDA, that's published by the Department of Labor, with the different regions and everything else, except for like California and Florida, who have their own specific ones. But ultimately, the different regions and one set wage for agriculture work. Regardless of if it's truck driving, construction, first line supervisor, anything, you get that one set wage. So any job order that's been filed with the department prior to October 2nd, when this rule goes into effect, gets handled under that. Any job order filed after October 2nd is going to be handled under this new rule. And as Arnulfo mentioned, unfortunately, the government has shut down, and the way that the Office of Foreign Labor Certification, which is the first step in the process, the way that department works is that's appropriations funded. It's not fee funded like USCIS is, where we can go to USCIS and still process during a government shutdown. During a government shutdown, OFLC shutters. So the system where Arnulfo and his team file your applications, it's called the FLAG system, the Foreign Labor Application Gateway system. That system is closed down. We can't access it. We can't even get online to it. We can't do anything. There's nothing that can be done. So any of the cases that are going to be filed October 2nd on that are going to be under this new IFR, we aren't able to process yet. We can't do anything until the government reopens. But any of those cases are going to be processed under this new IFR. There is a slight wrinkle in this that we have been watching, and we're waiting for some guidance from the department. But again, the department's closed, so we can't really get that guidance yet because they can't do any work. They can't do anything under what's called the Anti-Deficiency Act, which basically means that they can't spend money that they aren't appropriated to spend at this point. And so the slight wrinkle is that from the time that the rule was vacated, the 2023 rule was vacated in Louisiana, until October 2nd, there could be a period of time where there are people who were issued regular AWR wages under the FLS, the way that we were traditionally dealing with. So you get the 2092, the 20941, those wages, the ag equipment operator, the farm worker, the packing shed, the grader sorter, those wages, you could have been issued those, but you were also issued an SOC code that was different. So the heavy tractor trailer driver, the construction worker, the first line supervisor, those types of job SOC codes that ultimately would have resulted in a higher wage, but you were given the AWR wage that we were traditionally used to in 2010. So those particular cases from August 22nd until the government shutdown could face an impact where we're watching and we're trying to figure out how this is going to work, and we're waiting on more guidance from the government. But ultimately, what it seems like is going to happen is if you were issued one of these other OEWS codes, when this IFR went into effect on October 2nd, those OEWS wages would be owed, because those wages are higher than the wage that you were initially issued. So, if for instance, you were issued a 1275 wage for the AWR in whatever state you're in, but the SOC code that you were given for truck driving or construction or whatever was 20, 25, whatever an hour, you potentially have this aspect where you might have to make up back wages. We don't even know what those back wages might even look like at this point, because with the government shutdown, the department hasn't published what those wages are. And so that's something that we're watching. But ultimately, the main thing to understand is that if you filed before October 2nd and you were given one of the normal Big Six wage classifications, again, the ag equipment operator, the farm worker, farm hand, you were given grader sorter, the packer, those types of wages, we then are perfectly okay. We're not going to have to change anything, with regards to that, because that wage is probably higher than what wage you were going to be given under this IFR. But if you were given something separate that was, heavy tractor trailer driver, construction, or any of those other ones, that's something to definitely take a look at and watch to determine what potential adjustment you might have to make and what potential back wages you might have to make on that current contract. Going forward, the job orders that we're going to be filing, for the upcoming season for January 1 and further, those are going to be under this new rule. And so we're going to have the different levels and those things that we're going to talk about here in a second. I wanted to share this, but unfortunately, my computer system won't let me do it. I have a little write-up, and I'm going to give that to Arnulfo, and he'll be able to send it out to you guys, and you can take a look at it just to give an understanding a little bit of what the new wage levels are going to be. So what the department did in this IFR is they actually created two wage levels. They created what they call a level 1 wage, which is an entry level wage, and then they created a level 2 wage, which is the traditional, AWR that we're used to seeing. It's what's considered the mean wage. It's right in the middle of the wage categories. And so that is, basically the 50% level of whatever that wage is. So let me explain these two levels. The way that the department handles other immigration programs, I'm not sure if y'all are aware of the PERM program, which ultimately ends up with a lawful permanent resident card, but it's an employment-based program. There's also the H-1B program that uses these wage levels, and they break them down into 4 levels. The H-2A program is limiting those to 2 levels. But the 4 levels that they traditionally break them down into are the lower 1/3, the middle half, which is the mean, or just slightly below the mean, and then there's the mean, and then there's the upper 1/3 of the wage levels. And so they break them down into 4 categories. What they're doing in this IFR is they're giving us the entry level, which is the lower 1/3 wage, which is about 15 to 17th percentile of the wage level. And this is truly considered entry level. So we'll get into a little bit of what those requirements are to get to that level. And then there's the second level that they give, which is generally the mean. So that falls into the third wage level category generally of the way that DOL kind of breaks this down and statistically for the SOC codes. So the entry level category generally is going to be less than 3 months experience. And then they're going to break it down based on what your job description is. And so what they've really explained in this rule is, to get to that level 1 wage, which they think that vast majority of wages that are going to be issued under this new rule are going to be level 1. We'll see how that plays out. I kind of have a question on that. I think that, the majority of our applications that I've seen have generally 3 months or more experience required. But in their discussion of this, they talk about how it's going to be less than 3 months experience requirement, more on the job training type of things, not having, certain certifications for like pesticide application, even in like truck driving, not requiring CDL licenses and those types of things are going to allow you to be in that level 1 category. I think they might have overestimated the number that are going to be level 1 because I feel like the majority of what we're going to see is going to be level 2 unless we kind of, shift the way that our job classifications and job requirements are being articulated in the job orders. But level 1 is again, almost no experience, going to have on the job training, no real supervisory experience or anything necessary, no pesticide application, those types of things from the truck driving world, no CDL requirements, basically just baseline what is the lowest requirement for that job for you to be able to hire somebody. One of the things to really understand here, and the question that we get quite often is, well, what if I'm hiring somebody that I've hired for the last 10 years? Do I have to pay them level 2? The level requirements in this IFR and the way that they work it, it's not about the underlying person working the job. It's about the underlying job duties. So if you describe the job duties of, field harvester or whatever that's, less than 3 months experience, you'll provide on-the-job training. There's no supervisory requirements. They don't need a CDL license to drive the truck or anything else like that. You'll probably get one of those level 1 wages. Now, if you start adding in additional requirements, more than 3 months experience, having experience with pesticide application, having experience knowing how to first pick a harvest for, when the crop is ready. And, some of those types of things are going to potentially pull you outside of that level 1 wage and into that level 2 wage. That level 2 wage is going to be more traditionally tied to what we've experienced with the adverse effect wage rate. But ultimately, in pretty much 45 of the states, I think I've only seen 5 states where the level 2 wage is at or above the adverse effect wage rate we're dealing with right now. The majority of the states, that level 2 wage is still lower than the adverse effect wage rate. So it's going to be very, very, very important to get with Arnulfo and his team about what you require for those job classifications. And remember, it's the job order and the classifications of the job order that set that level wage, and the department and the state workforce agencies are going to work to determine what that wage is. You'll be given an opportunity to make corrections, make changes if they come at you with a level 2 wage when you think it should be a 1. So you'll have opportunities to make those changes. But it's going to require a lot more explanation as to what the job duties and what the requirements are. It's, again, not the requirements of the actual worker and what their skill level is. That worker could have that pesticide certification, they can have a CDL, they can have all of those things. But if they're applying for that level 1 job that you're advertising, it's still a level 1 job, and that's the required minimum wage. The other thing that a lot of people have been asking is, do we have to pay that lower wage? Or if we've been paying a higher wage for, the last however many years, can we pay workers that higher wage, to keep them coming back and everything else, and even their U.S. workers. The main thing that I've been telling people is if you're getting certified for that level 1 wage and you intend or expect that you're going to pay that higher wage that you had been paying in the past, that you need to disclose in the job order that there is an opportunity for additional wages to be paid, based on experience, based on tenure, job performance, those types of things. So if you add that kind of language into your job order, I think you're protected a little bit more on the back end if Wage and Hour comes in and says, well, you didn't disclose this to U.S. workers, and therefore, they could have applied if they knew that there was additional wages that could have been paid. And so that's, some of the stuff that we're trying to, hopefully get more guidance on from the department. We're kind of working off of our old traditional system with the wrinkle of these 2 new wage levels that are being thrown in. And so with those 2 new wage levels, it's going to add a wrinkle. There's going to be some growing pains that we're going to have to work through and figure out. And hopefully when the government reopens, we get, some good guidance and some FAQs that can kind of, explain how these different wage levels are going to work. One of the other questions that we're getting quite regularly is, can we have a mix of level 1 and level 2 duties on a job order? My personal thought is that, yes, you can have that mix, but based on the way that this is being described, I think you're still going to get, if you have level 2 duties, you're still going to get that level 2 wage for all duties on that job order. And so that's another thing to kind of consider and think about, because, we have not traditionally had, these 2 levels. I mean, we've had, the AWR that we have always known, and then we've had the disaggregated AWR that we have, kind of learned to deal with over the last couple of years. And they've always, issued the highest wage. And so I think that's going to be a similar thing that they're going to do, going forward, issuing that higher wage if you have a mixture of level 1 and level 2 duties in a particular job order. But it's something that we're, kind of waiting to figure out and how that's going to work. One of the other really good things that I liked from this IFR is something that we have been asking for many, many years, which is a primary duties test. So under the old rule, the 2023 rule that did this disaggregation, if you had one sentence, just one little sentence in there that says, driving, a 26,000 plus gross pound vehicle from field to market, you potentially were going to get hit with that heavy tractor trailer driver wage, even if it was a duty that was only being performed, 10%, let's say, of the work days or the work day. And so with that one little duty, everybody in your job order was going to get paid that heavy tractor trailer driver wage, which on average is about $25 to $28 an hour. And so they really ignored what has been a staple of the Fair Labor Standards Act, which is one of the other acts that the Department of Labor has to administer. And they've really ignored the aspect of what's called a primary duty. So it's what you do for the majority of the period of time during your workday. And so in this rule, they talk about how they're going to review what is the majority job classification, what is the majority of the job. So if 90% of the day it's field harvesting, hand harvesting, or grading, sorting, or whatever it is that falls under one of the FLS job classifications, they should issue you a wage under one of those FLS job classifications. What has gotten confusing about this is shortly after they talk about this in the final rule with regards to the primary duties, they then throw in this really random test about the majority of duties performed on the majority of workdays. And so it's really confusing as to how they're going to implement this. And again, we're waiting on a lot more guidance on what this means. My interpretation is this. So we have the primary duties, which, more than 51% of your duties are hand harvesting, grading, sorting, packing, whatever it is. 10% of those duties may be driving a truck, maybe erecting a fence, first line supervisor, whatever those duties are, but it's 10% of the duties. On the front end, I feel like DOL is probably going to issue a traditional FLS wage for one of those, FLS categories that we've talked about. On the back end, I feel like wage and hour is going to look at what duties were performed for the majority of the workdays. And so the example that I go back to quite often is you have a worker who every morning drives the van from employer housing to the work site, gets out of the van. For 90% of the day, he goes out and he's harvesting, he's doing, traditional farm work. And then for the next 20 minutes, he's driving the workers back home. So the way that they describe this is that on every single day he does this. So every single day he's hand harvesting, and every single day he's driving a truck. And so they're going to look at the confluence of all of that as to what are his majority of the duties. And so I think wage and hour is going to come in and on the back end take a look at, okay, well, you've done both of these duties every single day. And as long as you do one of those duties during the day, it's considered one of the work days. So it's not, a breakdown of the work days, with regards to that primary duties aspect. It's I drove a truck and I hand harvested. I did both duties on that day. That's a majority of the work days. Every single day I did both. And so the question that we have and what we're trying to get more guidance from DOL on when they reopen is how is this going to play out? Is wage and hour going to also take that majority of the workdays test that they're looking at and then also add in that primary duties test, right? So for only 10% of the day he's driving, but 90% of the day he's field harvesting. So his job is field harvesting. And so that's a big question that we have as to how this is going to play out and how they've explained it. Don't have answers right now. My assumption is it's going to be, as I explained, they're going to end up doing a primary duties test on the majority of the days. That can also just depend on the day that you get a wage and hour investigator and are they in a good mood or a bad mood? Are you being cooperative or do they think you're not being cooperative? I don't really know the answer to that right now. And so that's a really, really big question that we have with regards to how this is going to work. So I keep talking about the FLS duties and, what we have traditionally called the Big Six. So in this regulation, they have gotten rid of one of what's called the Big Six job classifications, which is basically called all other agriculture. They basically gotten rid of the all other agriculture. So now we're down to a farm worker, livestock worker, grader sorter, packing shed, and ag equipment operator. So those are our big five that they're going to issue the FLS wages for, which are no longer going to be the FLS because they're getting rid of the Farm Labor Survey. So what the department is doing is they're moving to the Occupational Employment Wage Survey that is done by the Bureau of Labor Statistics. One of the big knocks on the OEWS survey over the last many years is that it doesn't survey on-farm wages. And so what the OEWS actually surveys is your farm labor contractor, the manure spreader, the other kind of services that are provided to a farm, not by a farmer. And so that's been one of the big knocks on the OEWS survey because when you get into an area with not so many farm labor contractors, one farm labor contractor can really skew those wages. I think today I saw that New Hampshire and Vermont are two states that those wages are actually pretty skewed because there's not a lot of farm labor contractors in those states. But states with a lot of farm labor contractors, there's more respondents, and so the wages are typically lower. Like, for instance, in the state of Florida, the first level wage for the OEWS, as it's going to be reported right now for those traditional Big Five wages, is $12.71. Well, that's actually below the Florida state minimum wage because that just went up to, I think, $14 an hour this last year. And so there's been a lot of questions as to, all right, what wage do I pay? And so the AWR, the Big Five AWR, traditionally has always been higher than almost every state's minimum wage. And now we have several states that their state minimum wage is actually going to be higher than the adverse effect wage rate, as reported by the OEWS, at least for the next couple of years. So the question is which one do you pay? Obviously, you have to pay at least the minimum wage. So if you're in a state like Florida, where you're granted the level one Big Five wage, which is $12.71, and your state minimum wage is $14 an hour, you have to pay $14 an hour. You don't pay this $12.71, you're not able to go below the state minimum wage. So that's a new wrinkle that we're kind of watching for with regards to this. Another thing that's a little bit interesting about the way that we're changing this system. So traditionally, we have always watched for December for the adverse effect wage rate to be updated. The department typically updates sometime in December what that wage rate is because it's reported by USDA in November timeframe. The Department of Labor publishes it, mid-December. In years past, we've had 14 days to come into compliance. Under the 2023 rule, you had to come into compliance right away. Under this rule, that's going to shift. So no longer are we waiting on the updates in December. The updates are actually going to come July 1 every year. So in July 1 of every year, the new OEWS wage rates are going to come out, and we're going to have to monitor whether there's been a change up or down. Up, if it goes up, we're required to move up to that new wage rate. Also, many states are on completely different systems when they're updating their minimum wage. Some are updating January 1, some are updating July 1, some are updating at the end of the fiscal year, September 30th. And so you're going to need to watch your state's minimum wage to determine whether or not that minimum wage goes up and above what your adverse effect wage rate is that's been certified by the department. And then you're going to have to watch on July 1 to see if that wage changes as well. So there's quite a few changes that we're going to have to kind of monitor how these wages are updating and things like that. But the main point is to understand that if your state minimum wage goes above the wage you were certified for, you need to go up to the state minimum wage. If your certified wage goes up in July when OEWS comes out, you need to go up to the OEWS. The department was very clear that we do not get to go down. So if the OEWS wage goes down or the state minimum wage goes away and it goes back to federal minimum wage or something like that, you do not get to go down. So you still have to pay the same wage that you were certified by the department. It doesn't change to allow you to go down as we used to be able to do under the 2010 rule. And then one of the really more kind of interesting and exciting things to talk about with regards to what this rule has done is what's called the adverse compensation credit. And so the department recognized in this rulemaking that your domestic workforce that doesn't live in employer-provided housing, they have many other things that they have to pay for that they're not provided. They don't get provided with. Oh, there you go. Thank you, Arnulfo. That's helpful. So you can see a little bit of the number on the on the right side. This number allows you to adjust what. And let me see. I don't know if my pointer is pointing to this, but so for instance, Alabama is 1125. So in Alabama at skill level 1, 1125, this adverse compensation adjustment allows you to adjust that 1125 down by $1.20 an hour to H2A employees that are living in worker housing. And I say that right now as living in worker housing, and I'm going to get to my caveat on that here in a second. But what this adjustment kind of contemplates and understands is that your domestic workforce that's getting paid 1125, they have to pay for their rent slash mortgage, they have to pay for car insurance, they have to pay for gas, transportation, all of these other things they're being required to pay out of that 1125, while traditionally your H2A workers were getting 1125 and getting all of that stuff also applied for or compensated for based on the employer. And so what this adjustment allows for is to take into effect that kind of discriminatory aspect that, we're paying both domestic and H2A workers that 1125, but the H2A workers are getting this extra benefit on top of that they're not having to, compensate for. So this allows for the employer to be able to take a credit on those wages. So that would basically allow you to drop down for skill level 1 in Alabama to 10.05 as your hourly wage for H2A workers. You would still pay your domestic workers 1125. And as explained in the regulation right now, even migrant workers, so migrant workers that are coming and staying in employer provided housing, currently would still be paid 1125. You can't take the credit on any worker that is not an H2A worker. We have some strong questions on that and things that we're, hopefully going to be commenting on here coming up. The comment period ends in December, beginning of December, I think December 2nd. And so when that comment period ends, we're hoping that, everybody puts in, some good comments on this topic, because I think this is helpful. It helps give a little bit of a credit for, the other things, the other benefits that the employers have to provide to H2A workers. The big question, we have two big questions in this situation is, what about H2A workers that decide not to live in worker housing? Are you still able to take that credit? I think there's a very good argument that you are, because you're still required to provide that bed to that H2A worker. And so therefore that bed is empty. That H2A worker has a bed, but has chosen not to take that bed. And so we don't know if the answer from the Department of Labor is going to be, well, you can still take that adverse compensation credit, or if that worker is not taking that bed, you don't get to take that adverse compensation credit. The other thing that we're looking at is, again, these migrant workers. I've been talking to many different associations, groups, and everything, and some tell me that there's no migrant workers. Some tell me they have a lot of migrant workers that travel from outside the normal commuting distance. They stay in worker housing and those things. The way the rule is written right now, you cannot take a credit on those migrant workers that are staying in worker housing that are being provided that under the H2A program. And so that's a change that we're probably going to suggest to the department, that allows employers to be able to take that adverse compensation credit against workers that are staying in migrant housing. And then we're asking for that answer, okay, so are we able to take that credit against workers, H2A workers that decide to stay, with a family member or something else instead? And so there's still quite a few questions that we have surrounding this rule. All in all, it really does seem to be really beneficial. We'll see how, again, as we get into being able to file and the type of information that's going to be required now in the job order, the descriptions of of the job duties, the qualifications, the requirements, and those things. How detailed do we need to get into those? That's going to be a real big question that we're waiting on hearing. And then just how the different things are going to work with regards to this primary duties test, this majority of the days test. We still have a lot of questions around that. And unfortunately, because the government is shut down right now, we are unable to communicate with the department to really get any of these answers. And then, with how the OEWS wages are actually going to work for non-Big Five job duties, the department in publication of this rule published an Excel spreadsheet, but unfortunately, because the government is closed, we can't access that Excel spreadsheet. So we have no idea what those OEWS wages look like on a statewide basis. So it looks like it's going to be a good and helpful rule. I think we just need quite a few more answers for us to really understand exactly how beneficial this is going to be. The next shoe that we're waiting on to drop, other than additional guidance, is whether the worker advocates are going to challenge this rule. I think the department did a fantastic job articulating the need for the rule. They did a very good job of building out, their logical outgrowth of what needs to be done here, and why this rule is necessary. So I think there's very few areas for challenge. But I do expect that there will be a challenge to this rule at some point in the near future. As I mentioned at the outset, USDA discontinued the Farm Labor Survey. That happened in the previous Trump administration. When they first did it in the previous Trump administration, that was done under just an announcement from the Secretary of Agriculture that we're doing away with the survey. There was, no rulemaking or anything that was done that way, which made it ripe for challenge, and it was overturned. And so that's why we had to live with the Farm Labor Survey for the last couple of years. I think USDA did a very good job from the legal perspective of going through all of the hoops to discontinue the survey. They went through what's called the Paperwork Reduction Act, which I always call the Paperwork Creation Act, because that's all it does, is creates a lot more paperwork for everybody and the departments. But they went through that process to discontinue the survey. And so I think there's going to be a very difficult road ahead for any advocate who's going to challenge the discontinuation of that survey as they move into the use of the OEWS survey. So, they did a really good job, in my opinion, of setting this up so that it can survive. But as I tell every one of my clients every single day, it doesn't matter if you're wrong or right. Anybody can sue you on any given day, and you still have to pay me to defend it. And that's kind of where the department is right now. But with the department being closed, there's not a whole lot that anybody can do, because we don't really know 100% how this is going to affect every employer who's going to be using the program. So with that, Arnulfo, I think I have 15 minutes for questions. I can turn it back over to you and see if we have any.
Yes.
Do you have any questions?
That was a great, summary of what we know so far, and then waiting to get feedback. Obviously, looks like it could be, positive moving forward for the 2026 in regards to wages. One other thing, as Jamie's going through questions, if you could touch base briefly on what the rule change was for the staggering start dates. I know that was not as complex, so just a brief summary of what that means for some H2A users that have had multiple applications, and how that could cut down on cost.
No, absolutely. So a couple of months before all of this, and literally right before the vacatur of the 2023 rule, the department came out and got rid of some sub-regulatory guidance around staggered entry. And so we've been waiting on a little bit more guidance. Obviously, they got bogged down with trying to do this and everything, but from the couple of meetings that I've been to with OFLC staff and things, in essence, they are allowing employers to be able to stagger, and they haven't even put a time frame on this really yet. But ultimately, if you describe in your job order that you need 10 workers this month, you need 50 workers next month, and then you're getting into full harvest and you need 100 workers the following month. As long as you describe the dates when you need these workers to come in, they're going to allow you to stagger the entry of workers over that period of time, which is a huge change from what we've been allowed to do. One of the ways that I kind of look at it is if you're both in the H2A and the H2B program, staggered entry is allowed in seafood processing and the H2B program, and it's generally done over about 120 days. And then you have, certain other kind of recruitment requirements and things like that. They really didn't follow that model, and I kind of thought they were going to. And so their guidance really has just been, as long as you disclose it to us up front, and you tell us, like, I want 10 workers in December, I want another 50 in January, and then I want the remainder of my 100 in February. As long as you describe it to them that way, they're going to be okay with that staggering. And there's been very little guidance other than the couple of meetings that we've been to on that. So that's a huge change. And what that in essence does is instead of you having to file 3 applications for 3 separate needs, right? Your January to October, your February to October, or your March to October, those 3 separate definitive needs, they're allowing you to file 1 application. And then when you go to DHS, you just explain the same thing to DHS over that period of time. So that's going to be a real big helpful change and what's going on. And Arnulfo, I actually, speaking of DHS, I wanted to talk about the other IFR just real quick with regards to DHS on October 2nd also put out another interim final rule as well that allows for, I'm going to call it quote unquote electronic filing. It's not the traditional electronic filing that we're used to with the flag system where we do everything online and we just hit submit and it goes in. But in essence, what DHS is allowing is that once you get your notice of acceptance from DOL, so we file with DOL, within the first 7 days, they typically process, they give you either a notice of acceptance or notice of deficiency. But once you get your notice of acceptance, you go into that recruitment period. All right. Traditionally, we have to wait until that recruitment period is ended before we can file our recruitment report and then get a certification from DOL. And then once we get that certification from DOL, then we send a paper packet off to DHS and apply for the I-129 and the visa process through DHS. This IFR that they just issued is allowing you, once you get that notice of acceptance, to immediately go to DHS and submit a new I-129 application that they had put out. Arnulfo, correct me, I think it's the I-129 H2A. Is that correct, the term that they used?
Yes,
so it's the I-129 H2A. It's a new document, new application. It asks for a lot less information because DOL and DHS are already sharing all of this information, but it asks for a lot less information in the sense that if you're doing unnamed workers, so workers that are coming in from outside the country, going through the consulate process, they're not in country. If you're doing an unnamed worker petition, once you get your notice of acceptance, you can file with DHS your I-129, and then they will concurrently process both of those. And then as soon as DOL certifies your application, that information gets sent to DHS. And arguably what we're thinking, and when we haven't seen many of these happen yet because of the shutdown, but what we're thinking is that's going to cut off probably about 7 to 8 days of processing time, where we're having to then, get that certification from DOL, print that out, print the I-129 package, put that in a FedEx envelope, and send that off to DHS for them to process and then go through that process of doing it. So hopefully that's going to cut down on some of the processing time where they'll be able to concurrently process both of those. And so, that 15-day recruitment period, arguably what we're thinking is that on the 16th day, we should expect a certification from DHS and allow us to then go and process, through the consulate, do the interviews and other things. The other interesting thing that DHS announced over a month ago, but is coming into effect, I think in 10 days, I think it's the 26th, DHS is no longer accepting paper checks. So you're going to have to process your checks either through ACH, or not your checks, but your payment through ACH or through credit card. And so that should hopefully speed up the process a little bit as well. with regards to paper checks being processed and cashed and everything else. So hopefully we'll see a little bit of a net benefit in some of these changes. As I mentioned, the electronic filing at DHS is not really electronic. What they're allowing us to do is to print off that entire new I-129 package, have it signed, have all the wet signatures and everything else, and then we can scan that and upload it to their system, rather than spending the time to overnight FedEx documents.
Yeah, we're hopeful that that will be more consistent with the e-approval notices as well, as sometimes, when we're paper filing, we don't always get the e-notifications from DHS, which in turn allows us to start scheduling those appointments with the e-approval at the U.S. consulates rather than waiting on a snail mail, for those
Snail mail,
receipt
yeah.
notices or approval notices. So that would be very helpful in cutting down some days on those as well to get those appointments secured, hopefully prior to the start date so they can travel and be working on your start date of employment. So all positive changes so far from what it looks like. Jamie, I'll turn to you as we have a few minutes for any questions that may have came in. Also, you can, if you want to just speak up and ask Shawn a question or myself, just raise your hand and we can unmute your mic.
Do we have to pay for the employee's time to reach the desired workplace?
So the way the regulations work is you're supposed to pay from the place of recruitment. What we get into a lot of times is what makes it problematic is you've got a worker that you recruited, let's say from Jalisco or something, and then they're traveling to Monterey to do the interview. You're technically supposed to pay for that travel up to Monterey, the time in Monterey, and everything else as they go through that process. What we run into that makes it even more difficult is what happens when that worker gets thrown into administrative processing and then never actually becomes an employee. I recommend, in my particular, area, I recommend paying that worker for the time just so you don't have any issues, because it gets more of a headache. But technically, you're not required to pay that worker for the time if they've never become an employee. But yes, so from place of recruitment, hometown, all the way through to the process of them arriving at your farm, you're supposed to pay for the daily subsistence, the housing costs, and those types of things.
If an employer has always listed experience requirements, can they drop the requirements moving forward?
And that's a big question that we're getting quite often. My recommendation in that situation is if you're going to change year over year what you have been doing, explain it. Explain why you're making that change. Is there something that you're going to do differently? If you've always required 3+ months of experience and now you're going to require less than 3 months experience, are you going to provide on-the-job training? Are you going to do certain things? Because you got to remember what the point of this job order is at the initial outset is the recruitment of U.S. workers. So if you drop that 3 months experience that you've traditionally used because you've had somebody, walk up and say, hey, I want a job. I've never picked a strawberry on a farm a day in my life. If you're not going to train that person, they're not going to last. It's not going to be a good situation. So if you're going to change those job classification requirements from 3 months of experience picking strawberries, apples, whatever it may be, to less than 3 months experience, you probably need to add in some kind of on-the-job training to make sure that that person's going to have the opportunity to be successful. Because ultimately, the first step in this process really is recruiting U.S. workers. Once you don't recruit U.S. workers, which is what we typically see, I think it's less than 3% of these jobs are filled by U.S. workers. I think it might even be less than 1%. But once these U.S. workers do not show up to take the job, then it becomes the contract between you and the employee that you're hiring for the H-2A. And so if you're going to then end up hiring H-2A workers with less than 3 months experience, again, explain that you're either providing more on-the-job training, more supervision, or something like that. I think that's what's going to be required to go from, what you have traditionally filed for the last 8-10 years, however long it may be, to what you may be filing now to get in under that level 1 wage.
If there were no U.S. domestic workers and you only had H-2A workers living in employer-provided housing, would you still be able to take the adverse compensation adjustment?
So the way that it's explained right now is domestic workers are not entitled to the adverse compensation, and you're not entitled to take the adverse compensation adjustment for domestic workers. I think that's one of the things, again, in comments that I'm developing for other people that we're going to talk about, and suggest that may be something that changes. But any H-2A worker that is living in employer-provided housing, the adverse compensation adjustment is you're eligible to take that. The question we have now is, what about workers that decide to stay outside of worker housing? Like I said, I think there's a good argument that you can, because you still have to provide that bed for them anyway. But it's not clear. They haven't specifically articulated that. And so that's a question that we're going to be raising in our comments to the department, with regards to this aspect.
And you do recommend, Shawn, on that, if you plan on making that adjustment, we need to know and put that on the application up front.
Absolutely.
Even though it does not pertain to your local recruitment, but when that job order comes to contract for that individual H-2A worker, they need to know. So that's something to be thinking about now.
I absolutely agree with you, Artifo. I think that's something that we need to include in the job orders, that, if you're, as we understand it right now, if you're an H-2A worker, the adverse compensation adjustment will be applied at X rate, depending on your state, whatever it is. And again, that's going to be updated annually as well. So you're going to have to watch those annual updates. They may flow up, they may flow down. Things may change in that space. So it's just, it's another wrinkle to kind of add in.
Those are all the questions.
Perfect. Well, one other note to finish on a last positive note for H-2A. I know I sent out an alert in regards to the interview waiver process back in September, where the Department of State had got direction on canceling the interview waivers for all H-2 visa processing. Luckily for H-2A, come October, they are continuing that for the H-2A workers. Originally, Mission Mexico had reported that they would be required to interview an additional 350,000 individuals, for both H-2A and H-2B. As we know, H-2A does not have a quota, and that has the opportunity to continue to grow. But they will, H-2A workers who have received a visa within the last 12 months will qualify for an interview waiver. Now, they can still be subject to an interview at consular, discretion, but that is going to help speed up the process and continue to speed up the process, just like they have been. Now, unfortunately, H-2B is required for individual interviews for everyone. So those appointments will be scheduled differently and have a separate allotment. But for H-2A, another continued, change that will streamline the process for them as well. So thank you, Shawn, for your time. Thank you, everyone, for joining us. Like I said, Shawn has a memo we'll be sharing, and this recording as well for anybody who needs to follow up with it. Appreciate the time, Shawn.
Thank you, guys.
Thank you.